Van Hollen didn't raise his voice. He didn't need to. One question, one simple question about the meaning of the law, sent Pam Bondi spinning in circles, dodging, redirecting, and scrambling for an escape that never came. And the moment he pressed her on what zealous advocacy really means inside her Justice Department, the room shifted. Because if the nation's top law official can't define honesty in a courtroom without breaking into verbal gymnastics, what does that say about the system behind her? That's where this hearing went off the rails. And it only got wilder from here.
Madam Attorney General, yesterday, Erez Ruveni filed a whistleblower complaint against the Department of Justice. As I think you know, he was a 15-year veteran of the Department of Justice. He received commendations during the first Trump administration for all his work at DOJ, but he filed a detailed account of his recent experience at the Department of Justice, saying that prior to his determination, that he was terminated after he refused to sign an appeal brief that was unsupported by evidence or the law. And he says, "I didn't sign up to lie." In response to his termination, you made a statement on Fox News a little while ago saying, "At my direction, every Department of Justice attorney is required to zealously advocate on behalf of the United States, and that any attorney who fails to abide by this direction will face consequences." So, General Bondi, I guess the direct question is, he says he was fired because he didn't want to make an untruthful statement to a court of law. I have two questions. Number one, I assume you agree that zealous advocacy does not mean telling untruths to courts of law. And second, if that's not the case, what did you mean by saying he was not a zealous advocate?
Senator Van Hollen, this is all pending litigation, as you're well aware, and the timing of it, I can't discuss pending litigation. This is a whistleblower lawsuit pending within my office, but I will say the timing of it I find suspect, as he takes hits at Emil Bovee, who is one of the best human beings I know, one of the smartest, brilliant men I know, who will soon become a federal judge. And his hearing happens to be today, and I find the irony of the timing of it pretty remarkable, the lawsuit. But this had to do with attorney-client privilege information that was disclosed. I can't talk about the substance, but what I will tell you, and you have obviously my word, any zealous advocacy means to be done ethically and honestly, always. And that's what I mean by zealous advocacy. He also accused Emil Bovee of things that Todd Blanche, who is one of the best human beings I also know, my deputy attorney general, was in the room and said did not happen. But again, I wish I could get into greater detail. I can't because it's pending. But I stand by Emil Bovee and I stand by Todd Blanche every day, and I always will.
Well, Madam Attorney General, I will say that his account seems to have lots of information. So as you say, this will obviously be something that's litigated or reviewed through due process procedures. But I have to say that it's very, very disturbing. We've also heard from others in other departments who are responsible for implementing the laws of the United States, that they feel uncomfortable about having been asked to do things that they thought were unethical. Let me go on to some of the budget questions, and I really want to follow up on my colleagues, Senator Moran and Senator Collins. But the DOJ grant funding is being sort of cut back on two fronts. One, in April, the department terminated hundreds of grant awards, notifying grantees that their current grant funds were gone, effective immediately. That included, law enforcement training grants, technical assistance awards, some dating back to fiscal year, I think, 2017. So, question number one is, are you going to be releasing those funds? The second concern regarding grants has to do with the monies that were appropriated in this fiscal year, in March. And my understanding is that DOJ is withholding an overwhelming number of notices of funding opportunities, NOFOs, meaning that grantees who rely on these grants, including many who provide services to victims of crimes, are literally, in some cases, running out of money. For example, the department's biggest grant-making component, the Office of Justice Programs, has only posted one notice for fiscal year 25, NOFO notice. So if you could answer the question with respect to both those pieces.
Sure, and that's a very valid question, Senator. The notices will be going out in coming weeks about the grants. And we did cut grants by 6%, and I'm here to tell every senator, if we did cut a grant that you care about that is specific to your state, please contact me. I've turned on grants that were cut off. So please, if that happens, there's an appeal process, but you can pick up the phone and you can call me, and I would be more than happy to look at that. I never want to take away a grant that is actually helping Americans, helping victims, helping law enforcement, and we're looking at it on a case-by-case basis, and many of those are being appealed already, but you have my word, we will look at all of those, absolutely.
Thank you. And in terms of the other piece of the question, when the notices for information will go out, because the fiscal year obviously is, running out, and we are hearing from lots of entities that are waiting for those notices so they can apply for the grant funding.
Yeah, yes, Senator. The notice of funding is consistent with our priorities, and they're finalizing it right now. It will be going out very shortly.
Very shortly. All right. Thank you.
It'll be posted on a rolling basis, too, I believe.
Okay. If you could just keep us posted on that. And I would appreciate it, Madam Attorney General, if you could have your team or respond to a letter that about 30 senators wrote to you on this topic of the prior fiscal year funds that were frozen.
I will make sure they look at that letter. I think we've received probably thousands of letters.
You've got lots of letters. But we really do need, in order to do our job, to get responses. Thank you, Mr. Chairman.
Attorney General.
From whistleblower accusations to frozen victim service grants, Van Hollen peeled back a layer Bondi desperately wanted to keep sealed shut. And as he kept pushing, you could practically see the frustration brewing. Because every time he asked about the law, she answered with everything except the law. And that's why this exchange is blowing up. Because it revealed more than one complaint. It revealed a pattern. Van Hollen started with a case that sounded almost unbelievable. A 15-year veteran of the Department of Justice, Erez Ravini, filed a whistleblower complaint saying he was pushed to sign a legal brief that, in his words, wasn't backed by facts or the law. He refused. He said, "I didn't sign up to lie." And suddenly, he was out. For anyone who understands how the Justice Department works, that's not a small accusation. That's a direct hit at the ethical backbone of the institution. And Van Hollen wasn't about to let it slide. He laid it out calmly, but sharply. A decorated attorney who served multiple administrations says he was fired because he wouldn't make an untruthful representation to a court. Not because he was incompetent, not because he broke rules, but because he followed them. If that allegation is even partially true, it destroys the idea that DOJ lawyers serve justice first. And that's where the real tension began. Because Van Hollen didn't ask Bondi how she felt. He asked her one of the most basic legal questions imaginable. Does zealous advocacy include telling untruths to a court? A yes would be outrageous. A no would validate the whistleblower's point. Either way, Bondi was cornered. And that's where she first started to crack up. Bondi's response was immediate and telling. She didn't answer the question. She didn't even come close. Instead, she pivoted, declaring she couldn't discuss pending litigation. Then she suggested the timing of the complaint was suspicious. Then she defended her deputies. Then she insisted the whistleblower's story was wrong. Everything except answer the one thing Van Hollen had actually asked. For viewers watching at home, it was obvious. She wasn't just avoiding a question. She was avoiding the implications behind it. Because to say that zealous advocacy must always be honest is to admit firing someone for refusing to sign a questionable legal document is, at the very least, deeply suspicious. Her language got more tangled. Her tone tightened. She leaned heavily on attorney-client privilege, procedural boundaries, anything that could create distance between her and the whistleblower accusation. But here's the twist. Van Hollen wasn't accusing her of breaking privilege. He was asking her to define an ethical standard, the standard every DOJ attorney is supposed to follow. And she still wouldn't say it directly. That's when the hearing took a darker turn, because Van Hollen suggested Ravini wasn't the only one that he broadened the lens. Other officials, he said, in other departments, reported being asked to do things they believed crossed ethical lines. Some said they felt pressure. Some felt uncomfortable. Some believed they were being used to push political agendas instead of legal ones. In that moment, the story stopped being about a single whistleblower. It became a question about culture. Was the Justice Department turning into a place where loyalty mattered more than legal integrity? Where top officials were protected and truth-tellers were punished? Where silence was safer than speaking up? Bondi's reaction did not help her. She doubled down on two specific DOJ figures, Amal Boy and Todd Blanche, calling them brilliant, trustworthy, and morally impeccable. She kept circling back to defending them, almost as if the hearing were about their reputations instead of Ravini's allegations. But that was the problem. She was defending the department's power, not addressing the department's truth. And Van Hollen wasn't letting her escape. He shifted again, this time to something that affects people outside the courtroom: DOJ grant funding. This is where the hearing moved from internal ethics to real-world impact. Van Hollen brought up two serious issues. First, hundreds of grants, some dating back years, were abruptly terminated. Law enforcement initiatives, training programs, community safety efforts, just gone. Second, new grant notices for victim services weren't being released, leaving shelters, legal aid groups, crisis hotlines, and survivor support organizations running out of money. This wasn't hypothetical. This wasn't political theater. This was real harm. Victims of violent crimes depend on these programs for survival: housing, therapy, legal representation, trauma care. Cutting that funding without warning can destabilize entire states. Van Hollen's question was simple: are you going to restore the funds? And when will new funding opportunities be released? But Bondi's answers were vague, unsteady, almost improvised. She said there was a 6% cut. She said senators could call her if they disagreed. She said appeals were possible. She said notices were coming very soon. But people on the ground aren't waiting on phone calls. Victims in crisis don't live on senator to AG handshakes. They need structured funding, clear deadlines, and reliable systems, not promises drifting in uncertainty. And Van Hollen knew that. So he pushed again that he pressed Bondi to respond to a letter signed by about 30 senators demanding answers about frozen grants. She admitted they receive lots of letters. She said they try to look at it. Again, not an answer, just an echo. And that's when the full picture appeared. Throughout the entire exchange, Bondi seemed far more focused on shielding her staff, managing optics, and controlling the narrative than actually explaining how the Justice Department is supposed to work. And that's exactly why Van Hollen's questioning hit so hard. This wasn't an attack. It wasn't a political stunt. It was a test. Do you believe in the law or in the people who enforce it? Do you stand with whistleblowers or with the system they challenge? Do you protect victims or your own internal priorities? The more Bondi spoke, the clearer it became that she didn't want to confront the core issues. Every answer was a sidestep. Every reassurance was hollow. Every explanation circled back to trust, not transparency. And that's why this exchange exploded across social media and political discussions. It wasn't just a clash. It was a warning. A warning that when top officials can fire truth-tellers, dodge accountability, and freeze life-saving grants without meaningful oversight, the very meaning of justice comes under suspicion. And Van Hollen made sure that warning was heard. The final moments of the exchange were almost symbolic. Bondi tried to wrap things up by promising rolling notices very soon, consistent with priorities. But the message was already clear. Victims, whistleblowers, and the public were being asked to trust a department that couldn't answer the most basic question about honesty in a courtroom. Van Hollen didn't shout. He didn't grandstand. He didn't storm out. He simply laid out the facts, exposed the contradictions, and let her responses speak for themselves. And that's why the exchange went viral. Because nothing is more powerful than watching someone in authority struggle to explain why integrity seems optional inside their own agency. This wasn't about politics. It was about the rule of law, about truth, about accountability, about what happens behind closed doors when no one is watching. Until a whistleblower steps forward and a senator asks the question no one else will. And if one whistleblower can be punished for refusing to sign something he believed was dishonest, what message does that send to every other person inside the department? That honesty is optional, that truth is flexible, that silence is safer than speaking up? Those are questions Bondi never answered. But Van Hollen made sure the country heard them anyway. And that moment, those few minutes of tense, unfiltered scrutiny, showed exactly why oversight matters. Because without it, the truth gets buried, whistleblowers get silenced, and victims pay the price for decisions made behind polished podiums. What started as a simple question about the meaning of the law ended up revealing the deeper cracks in the system Bondi leads. And the look on her face said everything. She wasn't prepared for someone willing to trace the problem all the way to its roots. So the next time someone asks whether accountability still exists in Washington, remember this moment. Remember how quickly the facade fell apart when the questions got real. Remember that one whistleblower's refusal exposed something far bigger than a single firing. And remember that justice only survives when people are brave enough to challenge it, and others are brave enough to listen. If you found this breakdown eye-opening, hit that like button, subscribe, and turn on notifications, because the next hearing we're covering is even more controversial.